Welcome, everyone. This is the Courts Matter Illinois webinar on climate change and the environment. We will be starting in just a couple minutes. We're waiting for people to join us, and we will get started as soon as a few more people join. Thank you. I'm going to get us started with some housekeeping and some intro things, and then we will get going. People will be joining us. Let me explain how this works. My name is Carol Levine. I am the chair of Courts Matter Illinois and one of the founders of the coalition. I came to it I came to the courts about 20 years ago, and we established Courts Matter Illinois about 7-8 years ago. Full disclosure, I am not a lawyer, but I care deeply about the courts and the federal judiciary for a variety of reasons, which you'll learn about as we go along. Let me do a few housekeeping details to start with. All of your microphones are turned off, and all of your cameras are turned off. So if you have questions, down at the bottom of your screen, there's a Q&A box. We'd appreciate it if you put your questions there as you think of them and as you go along. If you have issues or things like that that you want to put down, use the chat box for that, and we'll monitor that as we go. I have a few thank yous to some organizations who are sponsors of these webinars, and I'd like to thank them in advance. They are Chicago Women Take Action, National Council of Jewish Women Chicago North Shore Section, National Council of Jewish Women State Policy Committee, National Council of Jewish Women South Cook Section, Planned Parenthood of Illinois, the American Constitution Society of Illinois, National Employment Lawyers Association of Illinois, and the Citizen Advocacy Center. With that, let me give you a little bit of background about Courts Matter Illinois. We are a coalition of diverse organizations and individuals working to ensure a federal judiciary that is comprised of judges who are committed to upholding core constitutional values. Now, you may wonder what core constitutional values are. They consist of things like voting rights, civil rights, workers' rights, freedom of speech, separation of religion and state, and the right to privacy, among other things. Here's some of the things that we do. We work to educate the public and our elected officials about the importance of federal judges and those who sit on the U.S. District Circuit and Supreme Court of the United States. We provide information to the community about the judicial nominations process and judicial nominees. We support a judicial process that is fair and it identifies well-qualified and diverse, unbiased, and nonpartisan nominees. We mobilize our communities to speak out and take action on federal judicial vacancies at any level of the federal judicial process, including the Supreme Court. Courts Matter Illinois monitors and takes action to ensure fair consideration of judicial nominations because of the immense power held by individuals who hold lifetime appointments on the federal bench. So, in order to do this, you have to understand how the nomination process works. So I'm going to take 5 minutes, no more, to explain that process through the use of about 8 slides, maybe 7. I don't remember exactly. So I'm going to use the slides to explain the federal judicial nominations process to you. Those of you who've been with us before have seen some of them, but I did change up a couple of slides. So here's Federal Courts 101. Let's go to the next slide. Okay, here's the federal court's makeup. The Supreme Court, 9 justices. Right now we have 8. The appellate courts, there are 12 circuits, 179 seats, and the district courts, 686 district judgeships. Please note that the Supreme Court hears about 80 cases of the 7,000 cases that are sent to them each year. This year, the Supreme Court heard one of the lowest number of cases ever. They heard less than 60 cases this year. Next slide. Okay, this is where you see what the various circuits look like. We in Illinois are in the 7th Circuit. There are only 3 states in our circuit: Wisconsin, Indiana, and Illinois. And there we are, right smack in the middle of the country. And if you look at the chart to the left on your screen, you can see that in 2018, the federal courts, not the Supreme Court, heard over 400,000 cases. Okay, compare that to the less than 100 that the Supreme Court heard, and you get a sense of the importance of the federal courts in total. Next slide. Here's the process the way it used to work. When there was a vacancy, the president would consult with the home state senators in the state where the vacancy existed for recommendations on candidates. Candidates were vetted by the White House, and a nomination was announced. Home state senators, if they approved of that candidate, would return what was called a blue slip, literally a blue piece of paper saying, yep, this guy's or woman or person is okay with me. The nomination would then go to the Judiciary Committee for a hearing. A yes or no vote was made, and it was then sent to the full Senate for approval. That's the former nomination process. Next slide. Here's the way it works and has been working, sort of working, today. When a vacancy has been created, the president would consult with the Heritage Foundation or the Federalist Society or other right-wing organizations, not necessarily the home state senator, and candidates that they recommended would be vetted by the White House. The nomination would be formally announced, and the White House would bypass, for the most part, the blue slip process. Once in a while, that might happen, but not usually. The nomination would go to the Judiciary Committee, where the hearings would be very rushed. Sometimes was what was called stacked, which means a number of nominations would be heard all at the same time. And members might get as much as 5 minutes to question a nominee. Remember, these are lifetime appointments. A yes or no vote would send that nominee to the floor of the Senate for a confirmation vote. Next slide. Okay, on the Senate floor, a number of the traditional processes that allowed debate on the floor, at times up to 30 hours of debate, were done away with under the Obama administration, not this administration. So now the majority leader can call for a vote with limited time for debate, and that time is up to 2 hours on the Senate floor. It takes a simple majority to confirm a judge for a lifetime position. So you only need 51 votes, and then you're confirmed for life on a federal court. And so with one party holding the majority of the seats, votes on the nominees are most often along party lines. The next slide, please. I thought it might be interesting to show you where we are with women judges, since that seems to be an issue right now in terms of the next Supreme Court nominee. Right now, women are 51% of the population. And right now, they have been, for about the last 2 decades, 50% or more of the law school students. But there are just 36% of the legal profession. And I'm having trouble reading this, but I believe that slide says they are 36% of all state. Now that's state court judges. Down at the bottom, they are 26.9% of all sitting federal judges. So you have a shrinking number of women who are represented in the judiciary, both professionally and on the courts as judges. So let's look at the last slide. I hope I'm staying to my 5 minutes. So here's what you can do. Pay attention to the courts. Raise awareness, use social media, and submit op-eds and letters to the editor and things like that about the courts, especially now. Call your senator, because they're the ones who vote on them, and urge them to reject extreme and unqualified nominees. Ask your networks, especially those in other states, because generally our senators in Illinois vote the way we want them to on court nominees. Educate others about the importance of the courts. Connect it to your ongoing work. And vote. Voting is indeed your superpower. Now, I will add this. We are, and we do in Courts Matter Illinois, take positions on court nominees. We have taken a position on the nomination of Amy Coney Barrett to the Supreme Court. We have taken a position of opposition to Amy Coney Barrett to the Supreme Court, and I will talk about that at the end of this webinar. Right now, and that completes this part of our introductions. Right now, what I want to do is introduce our panel and our moderator, who will then introduce our panel. So it gives me really great pleasure to introduce to you Miriam Judard, who is the Executive Director and a community lawyer at the Citizen Advocacy Center in Elmhurst, Illinois. Miriam practices in the area of sunshine laws and laws supporting civic engagement. She has empowered dozens of individuals and community groups to use various laws and civic skills to advocate for greater accountability of government entities. Miriam was nominated to the State Legislative Task Force on Civics Education in 2013, which resulted in the passage of legislation bringing civic education back to Illinois high schools as a graduation requirement. Her work with Benedictine University students resulted in amendments to the Illinois Open Meetings Act to guarantee the public right to speak at public meetings. Miriam has published a report on how the decentralized nature of local electoral boards in Illinois causes systemic barriers to voting access to the ballot and suppresses voter choice. Miriam clerked for the United States Court of Appeals for the Fifth Circuit after graduating from the University of California, Los Angeles School of Law with certificates in public interest law and policy and critical race studies. She is a member of the Illinois and California bars. She also is a valued member of the steering committee of Courts Matter Illinois. Miriam is going to moderate our webinar on Courts Matter to climate change and the environment, and she will introduce our really expert speakers. Thank you, Miriam.
Thanks so much, Carol. Welcome everyone again. I'm so happy that you've all joined us to discuss this really important topic with these great speakers we have lined up for you. And we'll talk about why this topic is so important, but just to point out some observations. We see a lot of extreme weather, huge wildfires on the west, and record-breaking temperatures, warm temperatures and cold temperatures. We're seeing increased flooding and the melting of polar ice caps and glaciers. And of course, all of this weather and climate change affects Illinoisans in the Great Lakes region and our Great Lakes. So without further ado, I'd like to introduce our three speakers. And I'll start with Debbie. Debbie Chizewer is the managing attorney of the newly created Midwest Regional Office of Earthjustice. Over the course of the last 2 decades, Debbie has advocated for environmental protection across many issues, fighting for environmental justice in the Midwest at Northwestern's Environmental Law Clinic, promoting Great Lakes health at the Alliance for the Great Lakes, and protecting wildlife and public lands in the Rockies for the National Wildlife Federation. Debbie also serves as the board chair for the Shriver Center on Poverty Law, a national nonprofit dedicated to promoting economic and racial justice. While at Northwestern's Environmental Advocacy Clinic, Debbie led the clinic's representation of a community group living on a Superfund site contaminated with lead and arsenic in East Chicago, Indiana. Her work in East Chicago was recognized with the NAACP Indiana Conference's Environmental Justice Award. As the managing attorney for Earthjustice's Chicago office, Debbie is in the process of growing the Midwest team and docket of cases across 3 program areas: climate and energy, healthy communities, and wild lands and wildlife. Mark Templeton is clinical professor of law, director of the Abrams Environmental Law Clinic at the University of Chicago Law School, and a research affiliate of the Energy Policy Institute at Chicago. Previously, Templeton was a trustee and executive director of the Office of Independent Trustees for the $20 billion Deepwater Horizon Oil Spill Trust. He served as the cabinet-level director of the Missouri Department of Natural Resources, leading the state's efforts in energy environmental protection, state parks, and water resources, and overseeing a staff of approximately 1,750 full-time employees and a $310 million annual budget. From 2005 to 2009, Templeton served as Associate Dean and COO at Yale Law School. From 2001 to 2005, he developed environmental and sustainability strategies at McKinsey & Company, among other projects. Prior to joining McKinsey, Templeton was special assistant and senior advisor to the U.S. Secretary of State for Democracy, Human Rights, and Labor, and an advisor to the U.S. delegation to the UN Commission on Human Rights. He was a financial analyst at Goldman Sachs from 1994 to 1996. Templeton earned an A.B. magna cum laude in social studies from Harvard College in 94 and a J.D. from Yale Law School in 99. Howard A. Lerner is the president and executive director at the Environmental Law and Policy Center. Howard Lerner is an experienced public interest litigation attorney serving as the president and executive director at EPLC, which is the Midwest's premier environmental legal advocacy and eco-business innovation organization. And among the nation's leaders, Mr. Lerner is responsible for the overall strategic leadership, policy direction, and financial platform of ELPC's successful work promoting clean energy development solutions to climate change problems, advancing transportation innovations and improvements, and preserving the Midwest's valued natural resources and heritage. Lerner founded ELPC in '93 as an entrepreneurial startup following his work as general counsel for business and professional people for the public interest, which specializes in policy advocacy and complex environmental, energy, economic development, and civil rights litigation in federal and state courts. He began his legal career as a civil rights attorney focusing on housing issues, neighborhood revitalization, and advancing economic inclusion for diverse communities. He served as a senior advisor for energy and environmental issues for President Obama in his successful campaign in 2007-08. Much of Mr. Lerner's work has concentrated on developing and advocating for new directions on environmental and energy policy issues. ELPC has been a leader in helping states and local municipalities develop clean, renewable energy and energy efficiency efforts. Not only does this work help reduce greenhouse gas emissions and pollution from fossil fuel power plants, it also helps create jobs across the Midwest and advance economic growth. So with that, I would like to end by saying that Mr. Lerner has also worked hard to protect the Great Lakes and the Midwest's wild and natural places, which include forests, waters, and biodiversity. So as you can see, we have a really well-rounded panel of experts on this issue. So let's move on to our first question, which I'd like all three panelists to answer in turn. Why should the public care about this issue? Why should they care about the courts and about how the courts matter to climate change and the environment?
Because if you care about moving climate change solutions and policies forward, you have to care about the courts, as well as the state legislators and Congress and city councils. You can't simply say, let's get legislation passed and not care if you have a Supreme Court that's going to reverse and overturn some of the legislation. What we're seeing happen, say, for example, on Obamacare, and the threats of what would happen perhaps with the Supreme Court if there are changes in the court when it comes to landmark decisions such as the Massachusetts versus EPA, Clean Air Act and Clean Climate Change decision. Courts matter, as the organization says.
Yes, please.
I'll just add, kind of building on Howard's point for a moment, that in the United States, we have agencies that make incredibly important determinations about how to actually implement these laws, and they promulgate rules and regulations, and also make individual permitting decisions. And basically, really the only defense we have against bad rules, which allow too much pollution to take place, too much carbon pollution, too much other kinds of pollution to take place, or bad decisions, for example, allowing too much leasing of federal coal that will be burned and create greenhouse gases. It's the courts. And so that's really where kind of the rubber hits the road and is a real check on the actions of these administrative agencies.
Thanks, Mark.
I'll pick up where Mark left off and say that these challenges in the court really relate to whether the agency's promulgation of rules are consistent with the statutes that they're promulgated under. And the Trump administration has rolled back more than 100 environmental regulations and is tempted to reverse the Obama administration's decisions and initiatives. And courts have been a backstop for this. Earthjustice has sued the Trump administration more than 100 times, and of the decisions where there have been decisions on the merits, we've won 41 out of 50, and that's in part because these processes that the Trump administration have been undertaking have not been consistent with the law, and the courts have been able to hold those back and allow the laws to stand.
Thank you for that. So it sounds like a lot of the case law in this arena really relies on the administrative state and its courts doing statutory interpretation. Would that be right?
Yes.
Can we then discuss next go over like an overview of significant cases from each of your perspectives, not only from your own experience, but also from you know, what case law exists out there that impacts what's happening on the ground now in our area. So if it's okay, I'm going to start with you, Debbie. I know that your organization, Earthjustice, has been involved in some really exciting, you know, lawsuits, important lawsuits.
Sure, thank you. I'll start by saying that, picking up on your point, Miriam, that courts serve to interpret the statutes and to check if rules are consistent with them. Most recently, the Supreme Court addressed the Clean Water Act in the context of a case called the County of Maui versus Hawaii Wildlife Fund. And that in that case, the Supreme Court held that the Clean Water Act does require a permit for the addition of pollutants into groundwater if that is the functional equivalent of a direct discharge from a point source to navigable waters. And what that means is, why that's important is that the county was discharging treated wastewater into groundwater and saying that it did not count as a discharge that should be regulated under the Clean Water Act, even though that discharge was getting right into the ocean. It was traveling directly from the groundwater to the ocean. And so this case is important because the federal government actually weighed in and was supporting industry and the County of Maui in this case to say that it should not be covered. And it would, if the court had ruled otherwise, it would have been left a huge loophole and would have allowed unpermitted discharge into our waters and would have undermined the whole purpose of the Clean Water Act. And so that's an example where the Supreme Court really protected the role of courts in interpreting the law and also protected our environment. And that's why courts are important. And, you know, Earthjustice represented the environmental organizations in that lawsuit. And we never, right now, it's hard to be in front of the Supreme Court. It's not something that we would seek out, but we were relieved to see that reason won out.
Okay, so that's wonderful. So that was for the Clean Water Act. Can another one of the panelists speak to any other cases that might affect our environment or climate in another area?
Sure. I'd be happy to do that. So I want to talk about carbon emissions, carbon dioxide emissions for a moment. There are a number of different important cases there. And I actually want to underscore the importance actually at the Court of Appeals level, which is where many of these cases are. Obviously, we'll kind of see what shakes out with the Supreme Court as well. But right now, under the Clean Air Act, basically when the EPA promulgates a new rule under the Clean Air Act, challenges come to the DC Circuit to review what EPA has promulgated. And right now before the DC Circuit are a couple of cases. So one relates to the Trump administration's rollback, replacement of the Clean Power Plan. The Clean Power Plan was an appropriate an important regulation of greenhouse gas emissions from existing coal-fired power plants. The Trump administration replaced that with something called the Affordable Clean Energy Rule that, needless to say, is not as protective, not as limiting of greenhouse gas emissions. Similarly, before the court, or there are different kind of phases. The Trump administration promulgated a revised approach to limiting emissions, greenhouse gas emissions from motor vehicles called the SAFE rule. Just gotta love some of these acronyms here. That again allow for more emissions over time to take place. I'll just note a third case, and I'll make one kind of connective point about these where we're involved. So there's also a pending case before the Ninth Circuit Court of Appeals, which covers vast stretches of the western part of the United States. Varies from year to year, about 40 to 45% of federal coal burned in the United States comes from federal lands, our lands. And those decisions are made by the Bureau of Land Management and other agencies in terms of leasing that coal and other environmental issues. So there's a case challenging a significant lease of that. And it's important because the Ninth Circuit a few years ago had a case which basically said, when looking at the environmental impacts of major decisions, essentially the agency can't treat the cost of those emissions as zero. They need to take account of them. And so I highlight these because these are, this is a major lease which will put a significant amount of CO2 emissions into the air if burned, even the broader kind of rural pieces as well. And those cases are going to be really critical. What we do is we basically promote good economics and good consideration of those costs through work that we do with one of my colleagues at the University of Chicago, Michael Greenstone, really promoting how EPA should be using a correct social cost of carbon. And I'll stop there, and Howard can chime in about some important cases.
All right, thank you so much. So two major acts that protect our environment, Clean Water Act and Clean Air Act, we brought up. Howard, do you have anything to add to that or about those two?
Sure. As the third speaker, I get to tie together some of the good things that Debbie and Mark said. First, Debbie's point earlier about the number of times environmental groups, Earthjustice, ELPC, NRDC, others have gone to the courts, and we've succeeded in reversing the Trump administration's environmental rollbacks. Keep in mind, when you're an attorney and you succeed before the court, you feel real good about the work you've done. But in many cases, these are cases that never should have had to be in court. We are winning, but we're winning on cases to stop rollbacks that never should have happened and that are bad for the public and are bad for the environment. And we got to get on the offense, not just be playing defense, because climate change isn't taking a pause. It's not like Mother Nature is saying, hey, Trump administration is rolling back the environmental standards, so don't worry about wildfires, don't worry about the Great Lakes hitting record high levels. Climate change is not taking a pause, and we need to act and move the ball forward. So a couple places where we're doing that is with the passing of Justice Ruth Bader, who was a hero to many of us and a very important record on environmental issues. To take a case Debbie mentioned, the County of Maui case, recognize that decision was 4-1-4. In other words, 4 in the majority, then a fifth opinion that had a different point of view that joined to make 5, that upheld Clean Water Act protections under more limited circumstances, and 4 dissenters. A little question in most of our minds that if Justice Ginsburg had not been in that vote, had it been a Justice Amy Coney Barrett, that would have come out the other way. So courts matter and justices matter. Justice Ruth Bader Ginsburg was a hero in so many ways on women's rights, employment issues, on leadership. She was also a leader on environmental issues. She wrote the lead opinion for the court in the American Electric Power versus Connecticut case. That's a climate change and clean air case that we were talking about before that left open. It did 2 things that are so important. First, it solidified the Supreme Court's Massachusetts versus EPA decision, the landmark Climate Change, Clean Air Act decision. Fact of the matter, everybody was wondering whether that 5-4 decision would stay in effect. It solidified it. Secondly, what it did was it left open the abilities of plaintiffs to proceed in state courts on Clean Air Act, Clean Water Act, and climate change initiatives. And as the federal courts closed down, and as the federal government has stepped back, what we've seen is states are stepping up. both state attorney generals, governors, and the state courts to act. And that's important. And that was part of Justice Ginsburg's opinion in that case. The third thing it did was it said that science matters. The court's opinion was based on, what science and technical expertise the US EPA had and what other parties brought to the table. In short, science matters. This isn't just politics. It can't go willy-nilly. Justice Ginsburg wrote the lead opinion in a case, Friends of the Earth versus Laidlaw Services. That's a leading case on standing. Now, standing's that really dry stuff. None of you are really interested in standing, but you should be for one particular reason. If you think courts matter, standing is the ability of environmental groups, community groups, conservation groups, civil rights groups to get into the door. If you don't have standing, you can't bring the lawsuit. So having a court that says we are open to environmental groups to considering the merits of your claim, as opposed to a court that says, hey, your claim may be well grounded, but you can't bring that claim here. You don't have standing. That's a big deal. Friends of the Earth versus Laidlaw Environmental Services is a big case for those of us who practice in this area. And again, you change the justices on the court, they bring different views to that sort of standing issue. And there are a lot of concerns about Seventh Circuit Judge Amy Coney Barrett. Mark referenced why courts of appeals decisions are so important. Some of her decisions in the U.S. Court of Appeals for the Seventh Circuit, she has a different view of standing, at least expressed in some opinions, than Justice Ruth Bader Ginsburg had. So those are places, climate change, clean air, clean water, where the courts really make a difference. At the Environmental Law and Policy Center, we're in front of district courts on clean water cases. Debbie and I were talking earlier today. We're doing cases up in Michigan involving the Enbridge Line 5 oil pipeline that would go through the Straits of Mackinac. Tremendous threat to water quality there in the Great Lakes. We're doing a major case in Minnesota involving the Enbridge Line 3 pipeline. Both of these are oil pipelines that would go in Minnesota through the headwaters of the Mississippi River area. This is, if there's another spill like Enbridge had in Kalamazoo, 1 million gallons that took years to clean up, could be just catastrophic. So we're all working together. Mark and the Abrams Clinic are doing the U.S. Steel case to try to protect Lake Michigan in Northwest Indiana. You referenced Debbie's earlier work in East Chicago, and the Environmental Law and Policy Center is taking on ArcelorMittal and its ammonia and cyanide pollution that led to 3,000 fish being killed and water being contaminated in Lake Michigan. So these are ones where we talk a lot together. And, Mark and I brainstormed the U.S. Steel and Arcelor case. Debbie and her team are working with us on the Line 5 case. We need to do this together to be most effective.
So, then, am I correct then in understanding that a lot of the litigation has pivoted to state courts because of that case that you mentioned, Howard, the RV, the electric power case?
It's really a both and. What it means is that as a plaintiff's attorney for an environmental group, or if you are the counsel to the city of Baltimore or the city of Oakland, you can look at it and you can say, what's the best venue for us to bring this case? And if the jurisprudence from the Supreme Court is that the door to the federal courthouse is getting closed down, maybe left open a crack, but closed down, but the state court door is open, we can bring our case forward. And having that ability to do both and, not either or, is extraordinarily important in getting to the issues that matter here to people. Climate solutions, healthier clean air for everybody to breathe, and safe clean water for everybody to drink.
Right.
Most of you folks aren't all that concerned about standing. You probably don't talk about it over the dinner table. You know, one of the problems that, you know, people like Debbie and Mark and I have is, you know, we talk, and Miriam, you know, we talk about standing, and we talk about jurisdiction, and that's what you have to do to get into the courthouse doors to have your case be heard.
Yeah,
And you mentioned several cases that affect us locally. Can you all, Debbie, Mark, and Howard, go into a little bit of detail about these local cases?
Sure. Before I do, I really wanted to pull out and reinforce something that Howard said that I think is really consistent with how I think about the role of judges and the importance of the judiciary. Howard talked about getting in the door and that we need judges who understand that it's important for advocates and community members to be able to get in the door and hold government and industry accountable. He talked about the judges and the role of science. And then third, he talked about, you know, upholding our laws, and that judges that recognize that there's a role for the federal government are important. And those three things are things I would recommend that people look for when they're thinking about judges. Is this judge going to allow people in the door, recognize the role of science, and recognize the need to uphold our laws and hold government and industry accountable? In terms of the local fights that we're all collaborating on a lot of issues. Mark is still involved in East Chicago, and we partnered on that work. As Howard said, we're working together, ELPC and Earthjustice, in the fight against Line 5. And I'll talk about that a little bit more now. So as Howard said, Enbridge is an oil company that has a series of oil pipelines that run across our country, including Line 5, which runs from Superior, Wisconsin to Sarnia, Ontario. So basically it goes from Canada, cuts through Wisconsin and Michigan and back to Canada. Right now it has pipelines that were built in 1953. Those pipelines are running underneath the Straits of Mackinac, which is the straits that connect Lake Michigan and Lake Huron. Those pipelines are really old, and they are they're in a very precarious situation. They've had many close calls, including one in June that caused the pipeline to be shut down temporarily. And the courts played a role in that. In that shutdown, the Attorney General of Michigan sought a temporary restraining order to have the pipeline shut down, and the court granted it. So that's an important example of how courts can that was a state court, but how courts can play a role. That fight now is about a proposal to build a tunnel underneath the bottom of the lakes to house this a new pipeline to replace these aging pipelines. But the plan for this pipeline is problematic and for the tunnel is problematic for a number of reasons. One is that it involves leaving the precarious pipelines in place for at least 5 more years, and where a spill could happen at any moment. 2, they involve something that's not been done before, building this massive tunnel underneath the lakes. And 3, it's an investment in fossil fuels at a time where we need to move away from fossil fuels and towards clean energy. And so we are all working together to employ a number of strategies in a variety of venues to fight this proposal and the pipeline altogether. And so there are proceedings before the Michigan Public Service Commission right now for regarding a permit application that Enbridge needs to get before that body. There's also a proceedings before the Army Corps of Engineers. There is a permit process there where parties are commenting that could ultimately lead to action in federal court, and also before another state agency, the Department of Environment, Great Lakes and Energy. All of these have the potential to lead to further court actions to stop the pipeline. And this is a chance to weigh in both on climate and protecting protecting our Great Lakes. Our role in this fight is to represent, Earthjustice is representing Bay Mills Indian community to lift up the interests of the tribal nation and ensure that its treaty protected resources are protected. And this is an example of how we need to make sure that all different voices are at the table and are getting access to courts and other proceedings. This is the first time that a tribe has ever intervened in a proceeding before the Michigan Public Service Commission. Now 4 tribes have intervened as in following Bay Mills leadership. And so that's an example of how we can use these processes at every level to make sure that different voices are heard and that we're addressing the threats of climate change and threats to the environment.
Thank you. So demonstrating that action being taken at the administrative level, and in this case, the state administrative level. And presumably, hopefully, that tribe would have standing in court to, when this case gets to court, as it probably will, that standing issue will come to bear.
Yeah, and actually, just to add one note, the comments that Bay Mills filed before the Army Corps of Engineers on the Clean Water Act permit that it needs reflect the other fights on pipelines that are happening around the country. So there's the Dakota Access Pipeline fight, which I can talk about later, but that fight is falling under a different statute than we've talked about before, the National Environmental Policy Act, NEPA, which is a law that's called the Magna Carta of environmental law because it's the first law that helped require government agencies to stop and look before they leap and involve public input. And much of recent decisions around NEPA really require the Army Corps to do more than it has been doing, and we have been making those arguments before the Army Corps here, and you can see how those same issues could play out in court, in federal court as well.
Great. Mark, do you want to add some more about some of the local cases that people that are listening to this webinar should know about and be following?
Sure, I'd be happy to. Let me talk about one that Howard mentioned, although I've got others too. And let's just say we are all working on a lot of different fronts. So if you're not hearing the case that piques your interest, just go to our website, because I promise you, we've got a case that will motivate you to care about these issues, from clean water to endangered species to energy, you name it. So a case that I want to talk about for a moment is Surfrider Foundation versus U.S. Steel. So we represent the Surfrider Foundation. A couple of years ago, basically the U.S. Steel facility in Portage, Indiana, released 300 pounds of hexavalent chromium into Lake Michigan in the Burns Harbor area. And basically, for those of you who don't know what hexavalent chromium is, think Erin Brockovich, right? That's the release of chemicals that made her famous. It's an extremely carcinogenic chemical. Again, U.S. Steel kind of released this because of malfunctioning, poor operations, poor maintenance, and basically their equipment falling apart. And it took them a while to even notify the authorities of this issue. We represent Surfrider Foundation. There is a great beach, basically immediately opposite of the U.S. Steel facility that people, all kinds of people enjoy the beach. The surfers who we work with set forth from that beach and surf right in front of the U.S. Steel facility. And in fact, some of those times were actually great surfing days. I know people may say surfing Lake Michigan, they may not actually believe it, but actually we have some of the best surfing in the Midwest, because basically the wind whips the full length of Lake Michigan. So you actually can get some pretty good waves there. And there's a dedicated group of people who are actually out there surfing. And so we sent a notice of intent on behalf of the Surfrider Foundation to sue U.S. Steel. When EPA did not act quickly enough, we then went ahead and the Department of Justice, we went ahead and filed a suit against U.S. Steel. And U.S. Steel even responded, the term is answered our complaint, admitting many of the violations, most of the violations that we alleged under the Clean Water Act. So not in dispute. I mean, some parts of it were, but the fundamental core pieces kind of not in dispute. Shortly thereafter, the Trump administration Department of Justice came in and filed its own case against U.S. Steel. I'll skip some of the procedural machinations here, but basically our case was put on hold while the U.S. government's case was proceeding against U.S. Steel. There was a penalty, damages to the Indiana Dunes National Lakeshore that was part of the proposed consent decree. We and thousands of other people objected to that consent decree. So the consent decree is when an enforcing agency, so like the U.S. Department of Justice and EPA in this case, could also happen at the state level. So the Illinois Environmental Protection Agency and the Attorney General's office reach an agreement with the party that violated the law. And they come to the court and say, we have, basically this is fair, appropriately negotiated, provide the rubber stamp, and the penalty will be paid and the company will take whatever the actions are. So we and several thousand people commented and pointed out in a lot of detail problems with this proposed consent decree. About a year later, the government came back and U.S. Steel came back with a revised consent decree, which would implement for several $100,000 an additional beach testing, basically water quality testing program. We still think that this is insufficient. And so this is all going to turn on the judge, right? We think that the federal government should have negotiated more with U.S. Steel. It's going to come down to the judge who's going to say that whether that is a sufficient penalty. Is that penalty really going to be enough to deter U.S. Steel from future violations? And by the way, they violated the law several times, Clean Water Act several times, including in exactly with the same chemicals and the same problems after their major violation. So is the judge going to hold them accountable or not? That, we've talked about the big rules, which are incredibly important, but on these day-to-day issues, these judicial appointments matter a lot in terms of whether the judges are actually going to step up and protect our environment, protect our shared natural resources, or say, close enough.
Right.
Maybe it's a little bit more than a slap on a wrist, but that's enough. So
that case,
that's one case that we're involved in locally in federal court in the Northern District of Indiana.
Okay, so that's in the lower level district court. Got it. Well, if you don't mind us pivoting a little bit to talking about kind of current trends in the courts. So I know, Mark, you just mentioned that the individual judges really matter in the cases because they get to decide things like, is that a sufficient penalty to deter a company from wrongdoing? And earlier Howard talked about how, without RBG on the Supreme Court, some, important decisions that kept our regulatory system in place would not have been kept in place if it wasn't RBG, and let's say it was possibly Amy Barrett Cohen. So can we talk a little bit about current trends in the court at the federal, but you can include the state level. So what are we seeing now that, we've seen 200 plus judges being confirmed, a quarter of our judiciary being confirmed by the Trump administration? What's happening with these kinds of issues? What can we expect?
All right, let's look at this in sort of a barbell fashion. what the Supreme Court decides in clean water, clean air, climate change cases is extraordinarily important because the lower courts need to follow it. But as I think you pointed out earlier, Supreme Court these days only takes about 80 cases a year. The court used to take 120 cases. So there are far fewer cases that the court's actually ruling on. The bread and butter, nuts and bolts work gets done by the US district courts and by the state courts. And when it comes to clean water issues, when it comes to clean air issues, the world has changed over the last 20 to 30 years. Very few of the district court judges instinctively are bad, if you will, on clean water. I mean, people are a product of society. You know, they watch the news, they read the newspapers, they have families and friends. So when you have a factual situation, like Mark's dealing with in the US Steel case, or we're dealing with in the ArcelorMittal case, I mean, those facts are pretty compelling. Judges know what cyanide is. They understand 3,000 dead fish turning up. They understand beaches being closed and water contamination problems. They may not know that people surf in Lake Michigan. You know, most of us in Chicago don't grow up humming Surfin' USA. But when it comes to protecting Lake Michigan, that really is a pretty shared value of most. So at the district court level, there are lots of differences among judges when it comes to how they assess legal issues. But we're really starting from a place, if you can show on the facts that there's a regulation that really harms the Great Lakes, or a company has, whether it's hexavalent chloride or cyanide, seriously contaminated Lake Michigan, you have a judge who's going to be interested in that. There just aren't a lot of judges these days, whoever they're appointed by, you know, who go on the bench to stand on the side of, you know, more water pollution is okay. So that's where the social change that's happened, starting with Earth Day 50 years ago, is really influencing the courts. These aren't new or novel or, you know, outlandish claims being made by extreme environmentalists. These are claims that are being made that are within the everyday concerns of people for safe, clean drinking water and to use and enjoy the Great Lakes where all of us live, work, and play. So that's how the courts have really changed, at least at the district court level and increasingly at the Court of Appeals. When the Supreme Court rules, and when it's, for example, in the County of Maui case that Debbie mentioned, I talked about earlier, 4-1 to 4 in terms of whether groundwater is subject to regulation under the Clean Water Act, that does make a difference because it affects what you can bring, whether you're ELPC or Earthjustice or the Abrams Clinic, what case you can actually bring in the court and what you have to prove. But with regard to the judges, we're starting off at a very different point these days in the district courts and the state courts than we did, and I'm sort of dating myself here, you know, when I started practicing environmental law years ago. And, you know, none of us on the panel are exactly fresh out of law school, to say the least. So that helps us a lot.
Mm-hmm. That's really interesting. Thanks for giving us that long view and to think about the fact that starting at the lower courts, this issue is really at the top of the judges' minds because they see what's happening, they read the names. Anyone else want to comment on this? This question of, you know, what are the current trends that we're seeing in federal and state courts with respect to environmental cases, and what can we expect? Something different than what Howard said.
I would just add that I think it factors into our strategy, right? So as courts change composition, we have to evaluate whether it's a good venue to bring our cases. And so we have to be really strategic about it as we're advocating on behalf of our clients.
I think we're approaching a kind of interesting, where does the rubber hit the road on a couple of these things? And I'll just say that, I think there's an increasing philosophy on the right side of the bench that basically wants to start scrutinizing more the efforts of the regulatory state, and from the judicial side, kind of start deconstructing the regulatory state. To me, the litmus test is going to be, are they actually going to do that to the decisions that the Trump administration has promulgated? Are they, or is it just going to be a matter of kind of being sympathetic when there's deconstruction of the efforts by the Obama administration, and who knows what will kind of shake out in the election? So in other words, is there actually a real judicial philosophy, or is it just cloaking what's really a political agenda being advanced in the courts?
So to take Mark's point here, let's call this is there a consistent judicial philosophy, or is it opportunistically applied? Okay. Mm-hmm. The so-called conservative wing of the court for years has been, if you will, a states' rights wing. That is, the federal government should leave the states alone. The states should have the ability to be, if you will, laboratories of democracy, and the states should be given some degree of deference and room to operate outside the federal parameters. So we mentioned the case earlier, American Electric Power versus Connecticut, which set the stage for a series of climate change actions, clean air lawsuits, being filed in the state courts instead of the federal courts. Now you have the irony of Exxon, and I believe Chevron, going to the US Supreme Court and saying, hey, these should not be in the state courts. We want them in the federal courts. If you look at the judicial philosophy of the conservative wing of the Supreme Court, they shouldn't be taking this case. And if they take the case, they should be saying, based on precedent, these cases are properly in the state courts. The state courts have the powers to adjudicate them. Exxon, you don't get to choose to put it into a federal court. Now, we're going to see what the Supreme Court does, and it really puts right on, up front, the point that Mark's raising. Is this consistent philosophy applied, or is it opportunistically pick and choose to get to a result that you want to get to? I'm cautiously optimistic we're going to be okay on this one, just because if the court were to close off the state court doors on stuff like this, it would affect a lot of other areas as well. But that's one where, we're going to see how the court handles that. But sort of to take the points that Mark and Debbie and I are making and sum them up a little bit, keep in mind, it may sound opportunistic where Debbie's saying, yes, let's go to the administrative agencies, which we do, or Mark's saying, well, we can go to the federal court or the state court. As attorneys, we have an obligation to zealously represent our clients' interests. And part of that is when you're a plaintiff's attorney for an environmental group, thinking about what's your best forum. Can you bring a case before a federal court? Can you bring it before a state court? And if you could bring it to both in representing your client's interests, which is the best forum? And that's one that we're thinking more and more about. And as you're seeing the sort of stacking of the courts by President Trump, that's very present on the minds, I think, of all public interest attorneys, whether it's people like Debbie, Mark, and I in the environmental area, or our good colleagues who are practicing in disability rights, civil rights, women's rights, civil liberties, and so forth. You're thinking about where are the different forums and which are the best places for the sort of case we want to bring. And you're also recognizing not just what the Supreme Court is saying, that's vitally important. That's what we read about in the newspapers. But you're also thinking about, as I mentioned earlier, hey, this is a pretty good clean water case. This district court judge is going to get this. And if the facts are good, and it's about protecting Lake Michigan, and there are some chemicals that were dumped and the company's actions are not laudable, I'm comfortable bringing that with most federal court, district court judges, as well as state court judges. We're in a different world these days in terms of judges are people, they're attorneys, and when it comes to core clean water issues, they get it.
So since judges are people, and a lot of them are attorneys, or they all are attorneys, usually anyway. I don't know, the Supreme Court, I'm trying to think if any of them were not attorneys ahead of time. Let's talk about the importance of having people on our courts with varying backgrounds. So, we're talking about diversity here. So not just diversity in ethnicity and racial diversity, but really more broadly speaking, diversity about how people grew up, their backgrounds, their perspectives. How does that affect this issue?
Well, we all, we come from somewhere, but key point on the current, if you will, diversity in one way of the court, you can look at it in terms of gender or race or political appointments. All 8 of the current justices were former U.S. Court of Appeals justices before they were elevated to the Supreme Court. And all of them went to either Harvard or Yale Law School. Okay, that sort of professional background, Harvard and Yale Law School, and served on the courts of appeals, is really a pretty narrow set of perspectives that get brought to the court. And that's the case whether they happen to be on the, if you will, liberal wing or conservative wing, or Obama appointees or Trump appointees and so forth. And I say that as a Harvard law grad. There's a broader world out there, folks.
But given that a lot of these cases are being decided, and maybe they don't get appealed and they don't go to an appellate court, like at the district level or in state courts, and we talked about how the individual judge, really might matter in a particular case, in determining standing or in determining whether the outcome is sufficient as a penalty to deter wrongdoing and environmental pollution. How might diversity serve this issue, diversity of judges in these systems?
I would say it's critical, and it's critical on a number of different levels. So there's the past practice, right? If you only came from representing corporations, and now you're faced with deciding whether a group that's suing a corporation should be allowed in court, it can't help but inform your understanding of the issues. And so having judges that represent, come from different practice areas, that's certainly going to affect their perspective and understanding of the issues. I have had the pleasure of attending events where many of the federal judges in district court in Chicago have spoken about who have come from diverse backgrounds, have talked about their experiences. And I believe that many of them have brought those with them and have an understanding of how real life can be. They've risen, there's one judge in our Chicago courts who went to law school while she had multiple kids, and she was balancing that while clerking herself. And I think that can't help but shape the way you hear cases and experience the law, and also who you choose to be clerks. There have been many stories about Justice Ginsburg and her time of going to law school with a baby, and also then having clerks who have had babies. And I think that opening up of our elite portions of our legal practice to people with all different backgrounds is critical, both for the perspective they bring, but also for people who are in the pipeline, whether they're in high school, college, or law school, but thinking about law, to see people who look like them and who are in these positions of power is critical.
Thanks, Debbie. Mark, did you want to add anything?
I think Howard and Debbie hit it pretty well. Thank you.
Okay. All right. Well, then let's then turn to the all-important question that is on all of our minds. What can we all do? Like, what action can we take to help to ensure that we have diverse judges on our benches? And that means diversity in many respects, including what practice area that they came from, and what can we do to help to protect our environment and our climate within the legal system.
First of all, keep in mind those are two really different questions.
Okay.
You know, for example, the contention will be made that President Trump's nomination of Judge Amy Coney Barrett advances diversity on the Supreme Court.
Mm-hmm.
You know, it is, from a gender standpoint, appointing a woman judge who certainly in an academic sense has strong credentials to replace Justice Ruth Bader Ginsburg. So that's a very different question in terms of what we can do for more diversity in different ways on the courts, of what we can do in terms of bringing stronger environmental values. Mm-hmm. So let me take the second one
Sure.
Because I think with regard to the nomination of Judge Amy Coney Barrett, both U.S. senators have expressed at least some views publicly, and I wouldn't think there would be among the listeners here a lot of difference with the views that Senator Duckworth and Senator Durbin have either expressed or are likely to express based on their past records. What we can do about environmental issues is, first, as people are looking at the criteria for judges who should be appointed, sometimes those criteria get pretty narrow in terms of issues and experience. Increasingly, we ought to be saying, are there people on the courts who care about the environment, who have done environmental law practices, who bring that experience to the courts, especially the district courts? Secondly, when the Supreme Court occasionally comes out with a decision that changes or rewrites statutes or constrains federal statutes, the statutory interpretation point that Debbie, Mark, and I all made, then you're talking about what can the legislature, what can Congress do to fix that? And that's about getting in support of our congressional delegation to not squabble all the time, but to fix some of those problems, which can be done in the statutory sense, particularly if there's some changes in Congress. And then finally, what can we do at the state level? You know, we saw, for example, whatever you happen to be on whatever side of it, Illinois step up and say, with regard to Roe versus Wade being under threat at the Supreme Court federal level, the state of Illinois is going to step up and pass legislation that protects the right of choice for women in Illinois. That passed the legislature last year. Likewise, we ought to be looking for opportunities, whether it's Illinois or other Midwestern states, at least where we operate, to advance state legislation if the federal government is stepping back. I mean, those are three things that people can get involved in, and I think they're all very important in different ways. Some people really like doing more of one than the other. They like working on federal or they like working on state. There's plenty to be done. And Debbie and Mark and I will be glad to work with you, Miriam, and with Carol and others to point people in a helpful and productive direction. Just let us know.
I just want to say a couple of things quickly. I would be remiss if I did not say that you should think about supporting the work of Howard at ELPC and Debbie at Earthjustice. And if you happen to be interested in supporting our work, that would be nice too. Because even under a changed administration, we're still going to have plenty of work to do against individual polluters and in making sure that the laws are as strong as possible, regardless of who the judges are who are going to be. Second, picking up on a point that Howard made, these Senate races, federal Senate races, US Senate races, and other places are critical to making sure that the right kind of people get nominated for the judiciary, critical for changing the laws, right? So again, kind of, if one of the conservative lines is, well, we're just textualists, we're just looking at the law, well, then let's get the text. Let's fix, if we need to fix the text in the law, let's fix the text in the law and get it super clear. You know, and so then that would make the cases stronger. A third thing is I would just encourage people kind of, you know, ways of contributing your time and talent, right? So if you've got expertise in an area, comment on these rules. Reach out to our organizations, right? We depend upon citizen scientists. We work with citizen scientists. We need people who can help provide standing. You have a network, you've got connections, you know people. All of these things are incredibly valuable resources, whether it's immediately on the judiciary side of things or back to helping to advance these kinds of cases. So, so many different kinds of contributions are needed. Everybody can contribute.
And I'll just add to all these great ideas that we've heard already that you can contact your senators right now and make clear your views. I know within about 3 days of Justice Ginsburg's passing, Senator Durbin noted that he had already received 40,000 letters about the process. And I think that's a critical role that constituents, everyday people can play, is making clear. You know, we're lucky in Illinois that our senators are strong on environmental issues, but you know, I think that it is important to make sure your voices are heard and along the way.
Great, thank you all so much. Really interesting points that you've all made that I'm hoping that everyone else on this call have learned a lot. And I'm going to turn now to Carol. So
well,
she can,
wait, we had one question for the panelists, and I don't want to neglect that. Well, that was a question about the state of philanthropy and your work in terms of legal issues. And it really was, you know, the state of philanthropy and the environment and whether or not philanthropy is rising to the occasion. And I'm going to sort of add to it because it wasn't tacked onto this question about whether or not that as it relates to litigation and your work in the courts.
Thank you so much. I'll start by saying that this is a unique moment in time where we have a short amount of time to make a difference on climate, and everything that the philanthropy community can do to support these fights to promote action on climate change and accountability is vital. And I would just add another layer to that. It's not just fighting climate change, and it's fighting for climate justice and ensuring that as we move forward with plans to address climate change, we are engaging communities that are most impacted by climate change now. These are the same communities that are being hit the hardest right now by pollution and by COVID, and these are communities of color, Black, Latinx, Indigenous communities that should be leading the conversation on climate justice, and philanthropy should also be devoting a tremendous amount of resources to helping those communities have a voice, whether it's through litigation or through conversation.
You know, I'll pick up on what Debbie said. Carol, this is an extraordinary time. We are literally dealing with 5 crises at once that are putting incredible stress on people in the overall system. You know, in no particular order, the COVID-19 pandemic that affects everyone in very, very different ways, and especially people who are lower income or are of color. the national moment and movement toward dealing with racial injustice. Climate change that isn't pausing, as I said before, and we are looking at rising water levels and flooding and hurricanes and wildfires. Climate change is a now crisis, as Debbie was saying. Fourth, the extreme volatility in the financial markets, that scare the heck out of anybody who has a little bit of assets, and most people who engage in philanthropy do. The market goes up one day by a big amount, drops like a big amount, and unemployment is at the highest level it's been in a long time. And then finally, just the stress and strain that so many of us feel with the President Trump and the national election. So for those of you who care deeply about the environment and who care deeply about climate change, Debbie, Mark, and I would all urge you the same. We lead not-for-profit organizations. We need your support. Please step up, okay? We can't sit here in good faith and say, step down on the groups that are on the front lines of dealing with COVID-19 in your local food pantries or racial injustice issues. All we can do is we are the executive directors or the leaders of major environmental groups. What we're doing is vitally important. It's of the time and of the moment. And we greatly appreciate folks who have the wherewithal to do so in the philanthropic community to step up and support us and support others who are doing the same sort of work.
Well, and
I was gonna say, I agree. And I think that actually foundations have been great partners in terms of people who have helped, ideas. I think for a lot of the work that's been done on energy over the past decade has obviously benefited from the foundations thinking more about the interrelationship between energy and climate change and environment, which is obviously true on a chemical and physical level, but I think they've been great supporters and great. That said, we do not have enough resources to fight on every front at the depth we want to fight. So we appreciate people's support.
thank you. Thank you. Let me sort of bring this to both a close and a call to action for all of us. And let me start first by saying something that I didn't say at the beginning, which was that we've recorded this webinar and we'll be posting it on our YouTube site along with all our other webinars. And it has been an amazingly informative and fabulous webinar, so that other people will be coming to that site to learn more, and we will be promoting it in that way as well. And I want to first of all thank all of our panelists for your wisdom and your insights, and for all that you're doing for the environment and for climate change. To Debbie, to Mark, and to Howard for everything you do. I want to thank Miriam for being such an able moderator. And I also want to thank Mike, who has been functioning behind the scenes. Mike is our Quartz Matter Illinois outreach coordinator, who has made everything run smoothly, because I am totally inept at these kinds of things. I totally appreciate him. Wait a minute, I just lost me because I obviously hit a wrong button. And I want to again thank our sponsoring organizations. And I want to thank everyone who joined us today for your participation. I want to remind you that we have the last of our 6 webinars in our Quartz Matter in the 2020 election series on Tuesday, October 13th. That webinar is on Quartz Matter to Reproductive Rights. It is on the second day of the hearings for Amy Coney Bryant. We're hoping there'll be in a lunch break when we do this webinar. You can already register for that on our Facebook site. So check out that site. It's at Quartz Matter Illinois. Just Google it and you can get there. And you can register for that webinar. And we hope you'll join us for that one as well. We hope that you'll also join our Quartz Matter Illinois family and advocate for a fair and just federal judiciary. And you can also email us with any questions at courtsmatterillinois@gmail.com. And now I want to give you just a couple of words about an action you can take right now regarding the nomination of Amy Coney Barrett to the Supreme Court of the United States. Courts Matter Illinois opposes this nomination, as we did when she was nominated to the Seventh Circuit Appellate Court. We believe that her judicial views will harm the powerless individuals who rely on the judiciary to safeguard their rights. We ask that you take action by doing the following. And I'm going to tell you what to do, but this also is already up on our Facebook site. So there's very little that if you don't have to write all this down, you can go to our Facebook site and get this. But we're asking you to call your senators. So, and to tell others. So it doesn't have to be just Illinois senators, but to call your senators. This is the U.S. Capitol switchboard number that I'm going to give you, 202-224-3121. I'm going to say it one more time, 202-224-3121. And I'm going to give you a script to let them know that the vacancy on the U.S. Supreme Court must be filled by the next president of the United States, and that Amy Coney Barrett should not be seated on the Supreme Court. Specifically, tell Senator Durbin that he should not grace this nomination with his presence in the Senate Judiciary Committee, nor should he meet with Amy Coney Barrett and give credence to her nomination. There is a whole script that you can read when you make your call. It's on our Facebook page, so you don't have to make anything up, and it doesn't really focus on Amy Coney Barrett. It focuses on what the Senate should be doing, which is things like providing relief and those suffering from the coronavirus and the pandemic, and those who are out of jobs, and the needs of women, children, and families requiring the attention of our Senate. So I urge you all to go to our Facebook site, find that script, make this call, and take some action on this. And please remember that courts matter. And please vote. It's your superpower. So use it. And use it now if you can vote early, and use it on November 3rd. And have a great afternoon, and thank you for joining us.
Good to join you all. Thanks for having us.
Thank you, Mariam, Carol, and Mike.
Thank you.
Be well.
Bye.